Good morning, everyone. Thank you so much for coming today to join this information session about understanding wills and estates. So as Danielle mentioned, my name is Debbie Sage. Joining me today is my colleague Natalie Comerford. Natalie is an estate planning lawyer at our Robina office, which is located just across the road here from the Anglican Church. That's right next door to the RACQ branch, as well as Pure Northology. And also joining me today is the lovely Jackie Kennedy from the Animal Welfare League. I've asked her to come along as well because there's some really important information that I thought you guys might want to know, especially those who have fur babies. All right. So to give you a little bit of background on myself, as Danielle mentioned, I'm a senior associate and an accredited aged care professional at Attwood Marshall Lawyers. I've been part of the Attwood Marshall family for over 16 years, and I've worked exclusively in the Wills and Estates Department and Elder Law for those 16 years. We are one of the biggest, if not the biggest, Wills and Estates team on the Gold Coast, and we have our main offices at Coolangatta, Robina and Kingscliff, but we also have offices in Brisbane, Sydney and Melbourne. So today I'm going to talk to you about wills and estates. In particular, I want to talk to you about wills and enduring powers of attorney. I want to talk to you about what they are, when they come into effect, some of the important things that you need to consider when you're making these documents, and the impact that it can have upon your estate. So I really hope that the information that I share with you today helps you understand the importance of having your documents drafted properly. And I welcome you to share this information with your friends and family. If I can just ask everyone to please leave your questions to the end, just so that we can make sure that we get through all the information that we have to share with you. There will be time at the end to answer questions, and Natalie, Jackie and myself will stay back for a short time to answer some questions as well. Before I begin, I also just want to let you know, of course, it is an information session, so it's intended for educational use only. It's not to be taken as legal advice for your individual circumstances or a substitute for seeking legal advice. Okay, so we do offer free 30-minute obligation-free appointments in our office to speak with one of our estate planning lawyers about your circumstances so you can understand what your options and strategies are. So first of all, we're going to talk about wills. Okay, so a will is a legal document which comes into effect when you pass away. It is prepared and executed while you are alive, and people can do multiple wills during their lifetime, which can sometimes make it a little bit difficult when it comes to administering your estate if it's not all held in the one place. One of the most common things I've come across during the pandemic especially is the case of missing wills. People not being able to locate their loved one's wills. They're sure that they did it somewhere in a vicinity of the Gold Coast or in the Kingscliff area or down in Sydney, but they just can't find it. Okay? There's been other situations where wills have been done at home and they've then been handwritten on in different pen, or they've unstapled the pages and then stapled them back together again, or there's a missing page. So these are the things that we see come across our desk all the time, which can become a very costly exercise when we're trying to prove your will. Another issue that we come across is the wrong will has been used. Okay, when another will is out there, but somebody else has come forward with a will and tried to use that as your most recent will, not realising that you have another will that you have made since that time. So at Attwood Marshall, what we do is, if you've come in and told us that you have made previous wills, we will ask for your consent to sign an authority to get your wills brought to us so we can keep them all together. We have a safe custody system at our head office at Coolangatta, exactly like a bank, but it's free to our clients, so it's bomb-proof, waterproof, fireproof, and we keep your legal documents in one place. Not only is it important to, keep them all in one place so that you've got, every single document out there and other people can't try to use them, but it's also really important to see what your previous decisions have been in the past. Because as you get older, sometimes you may make a will and you may be deemed to have lost capacity at that time, so they may need to look at what your previous decisions have been in order to determine whether or not it was something that was vastly different to what you've done before and the circumstances behind it. It also makes sense too if someone wants to challenge your will on the basis that they haven't been given adequate provision. So to have a look at your previous wills, have a look at the decisions you've made and why, also helps in that respect as well. So when you're making and preparing your will, one of the first things that you really need to consider first and foremost is your executor. Who you want to appoint as your executor. Your executor is that person or that people that you wish to appoint to represent your estate. So they are legally authorised to carry out your wishes, and they must sign all documents on behalf of the estate in order to carry out the administration. So you need to be able to trust them explicitly. One of the things that the executors will do is they need to call in your assets, they need to pay your bills, they need to decide what they're going to do with particular assets, okay? When to sell them, when to transfer them, those types of things. It seems like a simple task, but this is where a lot of executors find themselves in strife. You can have up to 4 executors at one time. However, again, it can be a bit problematic with 4 executors, especially geographically if they're not all located in the one area, because then you need to get all of their signatures, all of their decisions. It has to be a joint decision, unanimously, etc. Doesn't usually work too well if your executors do not get along. Okay, so that's something to consider as well. One of the things that we've come across these last few years especially is the executor clause needs to be drafted carefully. Now, over the years I've found that there have been many circumstances where executors have not been given the opportunity to step down. Now, it sounds like why not? But the executor clause needs to be drafted in a way to allow your executor, if they're not able to be able to renounce, step down as their role as executor and have somebody as a backup to take their place. Now, I've administered many estates over these last 16 years where that opportunity has not been given to the executor, and they've been extremely unwell, or they've been grieving, or they've even lost capacity. Okay? So you really need to make sure that that executor clause is drafted correctly to make sure that we cover each of these different sorts of circumstances to protect your estate and ensure that the person that you trust is the person that gets to stand up and act for you and carry out your wishes. You also want to make sure that the executor that you're appointed is trustworthy and reliable. Sounds like a simple thing to think about, but you've got to consider that carefully when you also consider who your beneficiaries are. Okay? So if they've been charged with theft, fraud, bankruptcy, those types of things, you may want to reconsider whether that person is suitable to your role and whether your beneficiaries are going to get the best representation in making sure they receive their entitlement properly. Again, sounds like a simple and straightforward process, but we come across these issues quite often where the executor doesn't like the beneficiaries, doesn't get along with the beneficiaries, or doesn't even keep in touch with the beneficiaries to let them know what's going on. Now, when we talk about bankruptcy does not preclude an executor from being able to act as your executor. However, they do need to disclose it to the court to let them know. And you've got to think about the practical aspects of that too, whether or not your beneficiaries may feel a little bit uneasy about somebody who is filing for bankruptcy or has filed for bankruptcy. It depends on the circumstances and it depends on you. It's your will, you decide, but you've just got to consider who the most reliable and trustworthy person is to represent your estate. Another executive issue which has been coming up quite a lot in the last few years is executors who have been appointed and they live overseas. Now, a lot of people don't realise that when you appoint an executor who is a non-resident of Australia for tax purposes, your estate is considered a non-resident of Australia for tax purposes. So perhaps when you otherwise would not have had to lodge tax returns, and you wouldn't even reach a threshold to have to lodge one for your estate will, and you will end up having to fall into the tax bracket as a non-resident of Australia. So you need to consider that very carefully. It's come across our desk quite a lot these last couple of years during the pandemic, where people have been stuck even overseas and have been deemed as a non-resident, and we've had to look into ways to get around that to protect your estate from having to pay those extra taxes. There are strategies involved that we can recommend to you, but again, those strategies still cost your estate extra money, and essentially you may not be having the executor that you had originally appointed to represent your estate because they've had to appoint somebody else in their place under a power of attorney or something like that. So you're effectively not choosing that person to be your executor, they're choosing that for you to be your representative. So moving on to burial and cremation wishes. Now you don't necessarily have to make a burial or cremation wish in your will, but this is where a lot of disputes arise. So I always want to talk about this with people because it's a costly exercise when there are disputes when it comes to burial or cremations, and it's extremely upsetting for family. So you've just got to remember that the person who is named as your executor is the person who is legally appointed to take possession and control of your body. Okay? And if there are signed instructions for you to be cremated, so for example, you place that wish in your will, or you have a prepaid or a pre-arranged funeral arrangement, then the executor has a duty to carry out what we call an instruction or an application to cremate you. Okay? The executor then must follow through to ensure that you are cremated. It doesn't always happen. There are 2 steps. So we've got to make sure that we follow through with that. The thing that people don't realise is people have the right to object to a cremation. This is where a lot of misunderstandings occur between family and loved ones. In Queensland, there is a legislation called the Cremation Act where a cremation cannot be carried out if a spouse, adult child, parent, executor, or a personal representative objects to the cremation. However, this does not apply where you have your own signed instructions to cremate. Okay? If you've made that direction and you have signed and written that down that you want to be cremated, you will be cremated. It overrides any objection that is made. Now, when we talk about the ashes again is an area where a lot of disputes arise between family members. Whoever applied for that permission to cremate you has the right to your ashes to the exclusion of all others. That includes your executor. So if your executor turns around and says, that's okay, you can handle the cremation, and that person is not the executor and goes ahead and makes that application to cremate, and then a fight occurs, whoever had made that application to cremate has the right to keep those ashes. Okay, so keep that in mind. When it comes to burials, unlike cremations, where you have instructions to be buried, it is considered to be a wish or a direction only. It is not legally binding. However, if you have already pre-purchased a burial plot and you haven't been buried yet and there is a dispute, then it is likely that the court will order that the body be buried because it shows your intention. You've prepaid a funeral plot. However, if you've already been buried and you're later discovered to have been buried in the wrong place, sounds interesting, I know, it happens a lot. The court will be reluctant to exhume your body and move you. Okay, so you just got to keep that in mind as well, to keep the lines of communication open, because the court may not even have the authority or the jurisdiction to do so if it's in a different state or territory. Now, when it comes to funeral arrangements happen all the time. However, I'm sure some or all of you may have heard of instances where there's been massive, extravagant funerals and it's been tens of thousands of dollars. Now, extravagant or unreasonable funeral expenses will generally not be allowed to be paid from the estate. Okay? The executor needs to obtain permission from all of the beneficiaries to seek their consent to ensure that they're okay with those extravagant funeral expenses being made. Or a way to get around that as well is you can pre-arrange your own funeral and sign off. So in those circumstances, it shows your intention. You've already, pre-arranged your own funeral and signed off on the costs. That shows that you as the estate have given your consent. Now, when we talk about the distribution of your estate, that we talk about how you want to leave your estate and to who. So we need to remember, this is really important because this is again where a lot of disputes arise or where a lot of court applications occur. You can only dispose of assets that are held in your name solely. Okay, sounds simple, but jointly owned assets do not form part of your estate. Okay, because they will pass to the survivor of the jointly owned asset, like joint bank accounts, for example. If you own a joint bank account with your spouse or your partner, then if you die first, under the laws of survivorship, that asset will pass on to the survivor, and upon their passing, it will then form part of their estate because it's now in their name solely. Does that make sense? Yeah? So it's important to understand how you own assets, and that includes especially how you own real estate, okay, how you own property, because this is where a lot of people give away things in their will and it fails because they don't actually own it, okay? You need to understand when things are held as joint tenants or as tenants in common. So at Attwood Marshall, when you come in and see us and you talk about your property, we ask you how it's owned. A lot of the time, people say they don't know, they're not sure. Sometimes it's because the bank are holding a title deed, there's not even title deeds anymore. We can do a title search and check that for you. Okay, title search is about $20 and it shows us how it's owned. Now, if you own something as joint tenants as opposed to tenants in common, same thing as a joint bank account, that property is owned 100% between you and the other people in the joint tenancy. It can be one, it can be two or more people. If you own something as tenants in common, it means that you own your own share. So when you see tenants in common on a property, for example, it will say tenants in common and equal shares, or a 1/3 share and a 1/4 share. You know, what that means is that particular share forms part of your estate and it will go as per your will. Okay. The other thing too is superannuation. Superannuation has its own laws. It does not necessarily mean that it will form part of your estate. So if you still have superannuation or you've got superannuation at the moment, we do recommend when you come in and see us, we do look at the whole picture. So we talk to you about your superannuation. We ask you whether or not you've got any binding death benefit nominations in there where you have pre-nominated who you would like to inherit your superannuation. We check whether it's valid. We check whether it's binding. We talk about whether or not it's, you know, non-lapsing or lapsing, because some superannuation companies, it will lapse after 3 years. So you've just got to understand that assets may not necessarily form part of your estate, so that's part of the education process that we go through with you as well. Now, one of the most important steps in estate planning as well is working out how you want to leave your estate and understanding what your needs, goals and objectives are. There are a number of different options and strategies on how you wish to leave your estate, so it's all about what you want to achieve. One of the biggest things that come into us, one of the biggest reasons or objectives is asset protection. Okay, so when we talk about asset protection, what does that mean to you? Do you want to make sure that your children's entitlement in the event that you go first is protected if your spouse repartners? Are you okay with your spouse repartnering, which could potentially have a whole new dependent for your partner? Which may override the obligations of your children who may now be adult children doing their own thing and are no longer considered dependents. So you need to consider, what are you trying to achieve? Do you want to try and protect your hard-earned money during your lifetime to ensure that it does go down to your children eventually? Or are you okay with the thought of your partner repartnering and potentially your children missing out? So there are lots of different strategies, they're not all difficult. Okay, that's part of what we do. We talk to you about all the different strategies that are available and what will work best for you. There is really no right or wrong answer when it comes to this sort of thing. It's about educating yourself and understanding whether or not you want to take that particular strategy and implement it, or whether you just want to take your chance and see what happens. The other one too is, do you want to try and protect your children from themselves, from the risk of divorce? The risk of a horrible son or daughter-in-law, the risk of perhaps, them not being able to take control of their inheritance and being taken away from them by their partners, bankruptcy, or perhaps they're in a profession where, it's a risky profession, like a doctor or a lawyer, an accountant, someone who may regularly get the risk of being sued. Or even a risk from themselves, okay, if they're a spendthrift or a gambler, or a drug addict, if you're concerned about them not using that money to the best of what you want them to use it for, there are strategies involved that we can help you understand to work out whether or not one of those strategies will work for you. Again, there's no right or wrong answer here. It's all about education and knowledge. and making sure that you understand what those options are for your circumstances to see and sit right with you as to how far you want to go to protect your estate. Now the next part I wanted to talk to you about is what we call the residuary estate. You've probably heard that quite often. Now the residuary estate is a common word used in wills to describe the portion of your estate that is left over after you have made any other specific legacies or other specific clauses where you've given specific things away, like a bank account or a certain sum of money or shares or whatever you like. This is generally where testamentary expenses are usually paid. So funeral costs, legal expenses, court fees, final bills such as credit cards, personal loans, unless they're attached to an asset, and utility bills, those sorts of things. So whatever is left over is called your residuary estate, and that is then distributed to whoever you have nominated in your will. You have to be very careful to ensure that you do contain a residuary estate clause. Again, this is something that's come across our desk a lot over the last few years, and it's usually when it's done with a do-it-yourself home-made will. They don't consider the fact that they need to leave enough money or enough assets in the residuary estate to cover your debts. I found over the years with homemade will kits, they'll sit down and work out what assets they have, and then they'll just give it all away as specific gifts to everyone. Where does your legal fees and court fees come from if you have to have your will proven, which more often than not is the case? You need to make sure that you've got enough assets held in your residuary estate to cover those expenses. You also need to consider as well that you may want to give everything away now in that way, but your circumstances do change in the future. You know, you may not have the same amount of money or assets when the time comes and you've passed. Okay? In fact, as you get older, you usually need more money to cover your care needs, medical bills, etc. when you're not working anymore and your assets are starting to diminish. So these are the kinds of things that you really need to think about when you're preparing your will. There are a lot of pitfalls that we see all the time in drafting areas, such as when gifts fail because you no longer own the asset, you've sold it and forgot to update your will. Where you've given assets away that you don't own or when they're jointly owned. There's not enough money in your estate to honour your wishes. That's a really common one, which becomes a costly exercise because everybody that's left something then has to lessen their entitlement in order to cover the costs of having to administer your estate. Then there are more complicated issues as well, such as family provision applications, where you haven't, someone feels that they haven't been left adequate provision in your estate, so they're challenging your estate. Again, there are strategies involved. If you've got someone that you don't necessarily want to leave your estate to, there are strategies involved which can mitigate those chances of someone contesting your estate. There are other applications that we have had to make over the years because of do-it-yourself wills usually, and that's where we make applications for construction or rectification. Construction is usually where we're making an application to the court for the court to make a decision as to what something in your will means. Okay. Sometimes I remember reading a case where someone had left $20,000 to John Smith, but he had 2 friends or 3 friends called John Smith. Who is that particularly referred to? Who is that person? Okay. There's been issues of rectification where a will has missed a page, but the Word document has been found. So the court need to have a look and make sure that they can rectify the will to insert that extra page, those sorts of things. There are also informal will applications that we make on a regular basis, and this is where you have made a document which you've intended to be your testamentary wishes, but it has not complied with the legal requirements of execution. Okay, it's, you usually hear about it in the news where it's a handwritten note that they've signed, or a tape that they've recorded themselves to tell them what their wishes are. That's when we have to make an application to the court for what we call an informal will application. It's a very costly exercise, whereas if you just get it properly drafted in the first place, you don't have to spend tens of thousands of dollars to get something over the line as being your final will. There are other complex grants that we've had to make over the years, especially during the pandemic. We've had to apply for what we call letters of administration where executors have lost capacity. okay, and there's no other backup executor, or the executor lives out of the jurisdiction, so living overseas and unable to get back. For a time there, we had executors that lived in South Africa and England, and there was no way we could get things done by post because the postal services had all stopped, planes had stopped. We were just in a whole new world at that point. So it's just a really good timely reminder now. It's a good investment to get your will done, okay, properly drafted, to save your estate paying tens of thousands of dollars, sometimes even hundreds of thousands of dollars down the track. It's almost like an insurance policy. You're prepared to spend that money on an insurance policy for peace of mind. The same thing goes when it comes to your estate. Now, if you don't have a will, okay, and this is happening quite often as well, if you don't have a will, then you are deemed to have died intestate. That's the word that you'll commonly hear as someone who's passed away without a will. Now, the rules of intestacy will apply to every state and territory. It all depends on whether your asset is held as to what rules will apply. Each state and territory have their own laws. Quite similar, but also vastly different. It depends on your circumstances as to whether you've got spouse, children, blended families. You may have a spouse now that isn't the parent to your children, so there are what we call statutory legacies that will apply. It can get very messy and very, very costly. It also, where we come across this issue as well, is de facto partners. So in Queensland, for example, a de facto partner for succession law, so wills and estates law, is a de facto is considered a de facto if you have been on a continuous relationship, a continuous basis for 2 years, up to and including when you passed away. So if you broke up for a little while and then got back together, you're not considered a de facto for Queensland succession law. Okay, so you just got to remember that as well. Now, how many of you here have pets? A few of you? Yeah? Okay. So for a lot of us, our pets are considered just as much as a family as our kids. Alright? Kids, spouse, brothers, sisters. So most of us assume that we're going to outlive our pets, but that's not usually, that's unfortunately not always the case. That is why I have asked lovely Jackie Kennedy to come, because there's an amazing program through the Animal Welfare League that I wanted to share with you today that I think is really important. So even if you don't have pets, but you have friends who do, I do recommend that you share this information.
Thank you, Debbie. That was so interesting. I've learned a lot today, and I think I need to revisit my own will. Thank you, Attwood Marshall, for inviting me along today. It's a real honour to be here and speak with you. So I'm just wondering how many of you know who the Animal Welfare League Queensland is? Yay! Most of you, that's wonderful. You may know us as the AWL Queensland. Now, I know only a few of you have pets, but this information might be important to other people in your family, that they're concerned their pet might outlive them. And we have a program, it's free to join, and it's called our Legacy Pet Program. Who will look after them after you? It's free to join. And the reason ours is free, other organisations might charge $5,000 per animal, $10,000, and I do know of one place that charges $20,000. The reason we don't charge a fee for this is because we believe that the welfare of any animal should never be subjected to how much someone can or cannot pay. And I have people all the time who are just desperate. They'll ring me up and they'll say, please, 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 can you put my little Rusty in your program, because I don't trust who's going to look after him if something happens to me. And sadly, in a lot of cases, well-intentioned people think, well, I can't look after this dog or cat, and they take it to their local vet and have the animal put to sleep. And this is tragic for us, because at Animal Welfare League Queensland we have a zero euthanasia policy of healthy, treatable and reclaimable pets. And we have no time limit on our animals. We've had a cat that's been in our care for over a year, keeps going in and out of foster care, and we are determined, no matter their age. We rehomed a 20-year-old cat. It was in perfect condition. Its teeth were beautiful, and it was adopted by a lovely young family and spent its lovely twilight years in a loving home. So we're very passionate about the welfare of your animals. I've got some booklets that you can take with you. There's the application in the back of the booklet, or if you go onto our website, at the top of the page it'll say Bequests and Legacy Pets, and you can just read through it all there and download the form. And otherwise you can just call me up and I'll be happy to help you. We also have another program. It's to help people who are 65 and older, and it's called Golden Hearts Seniors Pet Support Program. Once again, it's free to join, and once again, we really believe the importance of, the government's really supporting us to live for longer in our own homes, and I think that's fantastic. But they haven't thought about that in-between stage. A lot of us get lonely and we might get a pet, and that's our only reason for getting up in the morning. Takes us for a walk, our reason to the cat's nagging you to feed it. And so this is a program to support people while they're living. We have 50% of our annual vaccinations for the pets, 10% of everything else, and we also have emergency boarding program. When this program first started, which is 6 years ago now, Ida Buttrose is the ambassador for the program, and she's very passionate about the challenges that face senior-aged people, and she thought this was fabulous because she loves animals as well. So if you're stuck, maybe you've been taken urgently to hospital and you know that you've got a cat at home or a dog that's going to fret, we have our emergency foster and boarding program. It's free. The times I've spoken to paramedics before now, they'll say to me, we've gone to someone's home and they downright refuse to go to hospital because they've got 2 dogs at home. And it's very important to plan, not only for your own future, but your pet's future, not only when you pass on, but also what happens now. Have a think about, what would I do if, and this goes for any age group, what would happen if I was living on my own and I suddenly had to go to hospital? Who do I trust to have access to my house to help with my pets? And that's a very important thing to think about, because what if your pets are trapped inside? So this program, as I said, is free to join. Once again, I have application forms at the back here. I'm happy to speak to you that after the program. And we've got some little things that you can take away with you. These are great for people, once again, who live on their own. I do have fridge magnets, but I'll speak back at the office. So this one says, in case of emergency. If you do sign up for the Legacy Pet program, we want you to tell us as much about your pet as where does it sleep, what's its history. Does it have a special toy? So everything is planned, it's in our system. We give you a great alert poster for your fridge, and they know to call us immediately should anything happen to you. And so that doesn't only just support those pets you currently have, it supports any pets in your care at the time of your passing. That might be 20, 30 years. Let's hope. So that's a peace of mind and your backup plan for your pets. What else can I tell you about? That's it about our programs. Did you want to do a Q&A afterwards? Or?
Do you want to do a Q&A about the animal welfare leave now? Or would you like to leave it at the end?
Did anyone have a very quick question while I'm on the yes?
Actually, I'm just thinking of, I had an elderly mother, she no longer has a pet, but she lives in AVO.
Oh, yes.
The places, all the retirement villages have lots and lots of pets.
Yes.
Are you talking to people like AVO and now retirement villages?
Most of them know about us. It's kind of, the demand has enforced places like AVO to make it pet friendly. As you would know, or maybe know, once upon a time. If your mum's in there, feel free to take some of our book.
My mum actually, I've never been there too very
Yeah.
because they have meetings regularly, so I just thought,
Yeah.
as a guest speaker, I'm sure they would embrace you.
Yeah, thank
Issue
you.
for them.
Yeah.
Because when they have all their elderly folk, most of them are between roughly 70 to 98
Yeah,
with little puppies, and they're on the
yeah,
edge. To me, it's just
absolutely.
a very tragic situation.
And it's also important
Well,
to,
it's such a-
yeah. And that's a good idea. We are addressing that. Thank you. It's also a good idea to include it in your will. And we've got some suggested wording. Because if you don't have this spelt out in your will, we don't have claim over your animal. Even though those were your wishes, they go, oh, no, can't need here once Rusty. So, anyone else before we go? I hand back to Debbie. Anyone? Well, thank you for your time today, and I'll be at the back afterwards if you need to ask any questions. Thank you.
Thank you so much, Jackie. It's amazing information. I was amazed when I heard about the program, so I try and share it as much as I can because I love my animals as much as my children. And one of the things that I've noticed as well is when you've got one or more pets, when they're bonded pairs,
Yes.
you let them know that they're bonded pairs, they will make sure that they keep the animals together, and that when they're fostered or rehomed to a beautiful family, that they're always kept together. I can imagine if I tried to split my two pups up, it just would not go down very well. So now we're going to talk about enduring powers of attorney. Now, enduring powers of attorney, they normally go hand in hand with your will. So when you consider your estate plan isn't just your will, because obviously your will is what happens when you pass away. But what about when you're still alive? What happens in the event that you God forbid, are in an accident, or you're overseas and you get all your things stolen, your passports and things, and you need help? Or even just in the event that you're going in for an operation, or you just don't really want to handle your affairs too much anymore, like my mother, who just hands everything over to me as a power of attorney and says, you can just do all that sort of stuff for me, I don't really want to bother with that anymore. So an enduring power of attorney is where you appoint one or more people to act on your behalf should something happen and you wish for someone to step up and step into your shoes to make decisions for you. Now, an enduring power of attorney also means that it will continue to be effective even if you lack capacity in the future after it has been executed. Okay, so there's a difference between an enduring power of attorney and a general power of attorney. A general power of attorney is perhaps just something that you use for a specific period of time. You might go overseas and you're buying or selling a property, so you're appointing someone for a limited period of time. Whereas an enduring power of attorney, that word enduring means that it will continue to be effective even if you lack capacity in the future. So now you can appoint up to 4 people as your attorney. You can appoint them by majority if it's 3, or you can appoint them even in succession. So perhaps your partner first and then your children or things like that. Now, your enduring power of attorney covers your finances and your personal health matters. They're 2 separate sections of the document that you will refer to. Okay, with your financial matters, it can take effect immediately if that's what you want. Like my mother, she appoints me immediately, which means that I can do things such as pay her bills if necessary, or access information for her with Centrelink and things like that to try and access services and help her pay her bills or work out her pension. Then when it comes to your personal health matters, okay, this is all about deciding where you live, what health care you receive, what other kinds of personal services, and also consenting or refusing consent in accordance with your wishes. Now, this section of the document will not come into effect unless you lose capacity. That's even if it's temporarily, so if it's a short period of time, you're on heavy medication, you're in hospital in recovery, or you've had an accident, God forbid, or if you're going through, going through dementia. So again, it has to be when you've lost capacity, and you usually need to have a medical practitioner to sign off to say that you have lost capacity in order for that document, the personal health matters, to take effect. Now, in Queensland, you can still print these documents off the government website and do them yourselves. This is where we are coming across so many issues, okay, because not only is the new document just a lot more detailed and can get quite confusing, but they're not being done correctly. And sometimes that isn't brought to our attention until you've lost capacity, Sometimes it doesn't even suit your circumstances and you haven't really addressed it to the best of your ability, so it's not really suitable for what's happening in your life at that moment. And it's usually because whoever has done the document has not been properly educated on how powerful this document can be and the types of terms and conditions that we can put into that document to suit your circumstances. So when you come in and speak to us about a document like this, we go into quite a bit of detail. You know, we understand your circumstances. We go through what sorts of powers and what sorts of conditions that you want to make in your document so that we can tailor it to your specific needs. Now, we've seen it all. A lot of the things that I do at the moment is going through what we call the Queensland Civil and Administrative Tribunal as well as the New South Wales Tribunal, because these documents aren't being done correctly, or when they have, you know, they're not too bad. The attorney has sometimes misused their power and they've done things that they shouldn't have done. Whereas if you had put your mind to it, you could have told them whether or not they could or couldn't have done that, rather than leaving it blank and not really understanding what the extent of their power should be. So this is a very, very powerful legal document, and if you have lost capacity but you're still around, this attorney steps into your shoes and makes decisions for you. They can effectively decide where you live. They could move you into an aged care facility that you don't particularly like. They could move you into a different jurisdiction. They could take control of your bank accounts and sell your property when you really didn't want that to occur. Those sorts of things. We've seen it all. So I go into quite a bit of detail in this section when I do information sessions, because I cannot stress to you enough just how upsetting it can be for your loved ones to see an attorney misuse their power while you are vulnerable. Okay, so some of the things that we will talk to you about with this power of attorney are things like conflict transactions. Would you want your attorney to be able to enter into conflict transactions where their interest as your attorney may conflict with their interest as your spouse or your partner or your child, you know? Because they could be using your money to then go and buy a property in joint names, or they could sell down your property and buy it in a different entity. You know, who's going to know unless somebody reports it? Okay. Would you want them to be reimbursed for travelling or other expenses while acting as your attorney? This is a really big one that causes a lot of disputes between family members, especially siblings. So where one child has been appointed as an attorney but the other kids are left out, but then they notice that this person keeps reimbursing themselves for petrol costs. You know, they pay the bills first and then reimburse themselves, but they might do a little bit more. You know, they make up things that they might have to get reimbursed for, like food, you know, taking you out for lunch on you. You know, you've got to think about this. Do you want them to be able to be reimbursed? If your attorney practices the profession, and this happens a lot, what if your son or the attorney that you've appointed is an accountant or a carer? Or not a carer, she can't be an attorney, a lawyer, okay? Would you want them to be able to be paid their usual fees for acting for you to do a specific task? Because if you don't put that in, it would be considered a conflict of interest as well. Would you want to authorise your solicitor to disclose the contents of your will, but only in the event that you've lost capacity, and only to the extent that you may have specifically gifted property in your will that your attorney may need to know about? This happens a lot, where you may have specifically gifted your jewellery to a beneficiary, but you have lost capacity and so everything starts to get sold down. So what would happen? What do you think might happen to that poor beneficiary when you've passed away, only to realise that that attorney has gone and sold the jewellery or gone and sold the property? Okay, when that happens, in certain states in Australia, Queensland being one of them, the beneficiary can seek compensation from the estate. Okay, the laws will constantly change in this regard, but the beneficiaries can seek compensation from the estate in the event of an attorney selling down an asset when you've lost capacity. All right, so it's a really good idea to put that to your attorney's mind to say, okay, you know, mum's lost capacity. Is there something in the will that I need to know about? Perhaps you do have to sell down the property in order to fund their care or move them into care. If that's the case, you quarantine that asset. You make sure that you have a paper trail as to where those monies go so that the beneficiary can still receive their entitlement. examples such as that. Would you want your attorneys to seek appropriate legal or financial planning advice for any significant decisions that are about to be made on your behalf? Now, this is a big one for me. As an accredited aged care professional, I see time and time again family members who are appointed as attorneys, or just attorneys in general, trying to sell down the family home thinking that they have to sell it in order to fund their parents' way into care. That's not always the case. In fact, you may be actually putting their whole circumstances to their detriment because you're selling down an asset and causing them to have too much money in the bank account to enable them to have a pension. So what you've got to do is you've got to put your mind to this. Would you want, if they're about to sell $1 million asset or a $600,000 asset in order to fund your way into care, would you want them to receive proper financial advice first from an accredited aged care professional, for example, to see what options there are? Because there are numerous options when it comes to aged care. You don't have to sell the family home. In fact, we have dealt with disputes where they are repartnered and they've got a partner being at home with them, mum or dad goes into care and the attorney tries to kick the partner out. You don't own that property. We've got to sell down, we've got to get mum into care. The whole thing is there's a thing called protected persons. That person is protected, that asset is protected. If there is someone considered a protected person in your home, they will not count that asset for income and asset purposes when you assess your aged care fees and things like that. So you've really got to consider, your attorney really does, I believe, have a duty to seek appropriate advice to make sure that they look at what the different options are available to them, looking to see what the cash flow will be, looking to see what the cash flow deficit over a 5-year period to work out which option may be best. It might be better to rent the home for a couple of years before selling it later down the track. Or maybe mum might not even like that and want to go home. You know, there's different strategies that are involved. So this is one of the clauses that I usually highly recommend putting in a power of attorney, because we've just seen the other side of that where, you know, people end up in nursing home or in aged care facilities and they've lost the pension because they've got too much money in their bank. Okay. Digital assets. One of the biggest things that we think about, we all live online. Most of us live online now. We've got emails, we've got multiple emails a lot of the time, we've got social media accounts, you've got laptops, you've got desktop computers, you've all got passwords. Okay? There is a clause that we can put in your power of attorney to enable your attorney to have access to your digital assets. So being able to access your storage devices, your email addresses, things like that. So for example, with myself, I don't get invoices and bills sent to my home address anymore. Everything gets sent to my email because I'm trying to save the environment. How do you think that's going to work for your attorney if your attorney can't get access to your email? Okay. Another one is with your superannuation. If you've still got superannuation, would you want your attorney to be able to renew your binding death benefit nomination in the event that it lapses every 3 years? This happens a lot too. So let's say you've still got super, you've appointed, you know, some children or your partner as, but your binding nomination lapses every 3 years, but you've lost capacity. Would you want your attorney to continue to renew that? They can't change it, but they can keep renewing it for you to ensure that it's valid. The difference between making it binding and non-binding is binding means that your beneficiary, if it's found that it's a valid binding nomination on your death, they'll get paid a lot quicker from that superannuation money. But if it's non-binding, it's then left up to the trustees of the super fund as to who is going to receive your superannuation. And that can take 6, 12, 18 months. It just depends on your circumstances and how quickly they can provide all the information they need to provide to give them the overall picture as to who is in your life and considered dependents and things like that. Would you want your attorneys to give reasonable gifts? You know, sometimes you might give your grandchildren $50 at Christmas every year. Would you want your attorney to continue to do so? Okay? If that's the case, then you may want to specifically put something in there to allow them to do that without other family members saying, why are you doing that for? That's not fair. You know, you're taking money out of mum or dad's money, and you know, it causes difficulty. It causes strain on relationships. Would you want to empower your attorneys to continue to provide for your spouse or an adult child that may be still living at home, that may have a disability, for example, or may have needs, to the extent that you have always done so during your relationship with them. That's a really big one, because, you know, if you've lost capacity, they can't necessarily start dipping into your money as attorney and start using it to benefit another person. That's not acting in your best interest, is it? So if you put that in your power of attorney, or you have to specifically word it well in order for you to be, for it to be valid and binding and not cause issues with other family members and interested parties. But it's a really important one to consider. The other one too is, would you want to remain at home for as long as possible? That putting you into an aged care facility is the last resort, and only in the event that they have exhausted all other avenues, so they don't just give up and say it's all too hard, we're just going to put you in a facility now. If you put something quite specifically in your power of attorney, it's really quite powerful, because you're setting the standard. You're letting them know that this is what you want. I don't want to be moved into a facility too quickly, or if you do, I want to stay in this area, or I want to be moved closer to my daughter, or I want to be in this facility if I can, because my friends are already there. So there are things that you can put in your power of attorney to make it very specific to ensure that your wishes are being heard. The big one, which has been coming across quite a lot, especially in circumstances of asset protection, okay, is, would you want to restrict your attorney from being able to transfer the title of your home from tenants in common to joint tenants? Now, it sounds like you shouldn't even have to think about that, but this is something we come across all the time. Sometimes we will restructure your assets, okay, to protect them, for your asset protection, to achieve your goals, your needs, goals and objectives, and part of that may be where we change the ownership of your home from joint tenants to tenants in common. But what if you lose capacity down the track? And what if the other person is your spouse, is your attorney, for example? And what you've done may go out the window if you lose capacity and they downsize. And they go and downsize and decide to buy the property as joint tenants. Oops, it's no longer part of your estate anymore. So you want to make sure that you put these kinds of things in your power of attorney and be as specific as possible. This is really important when we strategize with you. Okay, so these are the types of things that we'll talk about, and it's all part and parcel of protecting your estate to achieve your goals. And the last one I wanted to talk about is the do not resuscitate clause. Okay, this is probably one of the most common clauses that we put in, and it's a very detailed clause. And this is where we want to put your mind to whether or not you are in a permanent vegetative state, or if you're in an incurable illness unlikely to survive, whether or not you would want to be resuscitated given artificial hydration or nutrition and things like that. So we go into quite a lot of detail to make sure that whatever it is that you want is exactly what you want to achieve. I had a client once, many years ago, who said to me, I want to do not resuscitate clause, but I don't want to be dehydrated. Okay, so I want to be artificially hydrated, but I don't want to be artificially neutralized. So it's all about tailoring it to your needs and making sure that your attorney can advocate for you when the time comes, and can show the doctors that you have put your mind to that already, and let them know that this is exactly what I want in my final days. Or it may not be your final days. You know, you may just be in a coma and you may come out and you may be able to survive. So these are the things that you want to do to ensure that your attorney has the ability to step up and advocate for you. So these are just a few examples of the things that we do to advocate and help you have your attorneys advocate for you and make your power of attorney powerful. Okay? It not only protects you, but it also allows them to be able to understand what they can and can't do. Now, if you don't have a power of attorney, which is happening quite a lot at the moment as well, where you don't have a power of attorney, and you aren't able to make decisions for yourself, usually this happens in a hospital, where they say that you're not able to go home because you're at risk, there's nobody who can make decisions for you, they make urgent applications to QCAT, or Queensland Civil and Administrative Tribunal. This process is a long, daunting process, okay? Your family members have to put their hand up to take on that role, to fill out all those forms, dig out all your assets and work out what you've got and come up with a plan as to what they can do and why they're suitable and those kinds of things. The process can be very, very upsetting and long-winded and expensive when you get lawyers involved to try and help them. And there's also situations where siblings or interested parties will fight and say, you're not suitable, neither are you. In those circumstances where the tribunals see that there is a dispute between interested parties, more often than not they will appoint the Queensland Public Trustee. Now they have a place in our society, but it's not ideal. And it's really upsetting to your loved ones to see your loved ones being treated as a number and not really considering what your real needs are, just what's convenient for the public trustee. So I hope this information has been useful. That's all from my information session. We're ready for questions if any of you would like to.